don't agree with the ruling of the Magistrates Court because the magistrate looked at the Kenya Information Communication Act. Those are the provisions that have been repealed. They have been declared unconstitutional. The provisions that the DPP charged are in Section 16 of the Cybercrime Act. They have not been declared unconstitutional. They have not been declared illegal, and therefore the decision of the learned magistrate is not sound law. But that I don't have the capacity to reverse that decision. The Director of Public Prosecution shall be moving to the High Court to reverse that decision. We are discussing about the charge of Rose Njeri. The charge is misuse of Cybercrime Act, contrary to Section 16 of that Act. The learned magistrate looked at the provisions of the Kenya Information Communication Act, which has almost similar ingredients to the Cybercrime Act. In law, you cannot import what looks like. You deal with the actual provision of the law of how Njeri was charged. She was charged under Section 16, the Cybercrime Act, and the magistrate did not have the jurisdiction to declare Section 16 of the Cybercrime Act unconstitutional. That is a preserve of the High Court. And that's why we are saying the import of a generic argument that because the Information Act was declared unconstitutional and the ingredients look like the Cybercrime Act was importing wrong provisions of the law to apply to a specific charge. And that is why, in my own view, I find that the learned judge overstepped in his mandate to not admit the charge. And as I've said, the Director of Public Prosecution shall challenge that decision on Monday so that the High Court can provide a roadmap. The current Law Society of Kenya president, the former, the Chief Justice, Senior Counsel Kalonzo Musyoka, are lawyers of high status. They put their arguments. The learned magistrate agreed with their arguments. Their arguments for now carried the day. In my own divergent view, I do not agree with the arguments of my seniors. It is allowed. Seniority does not become the law. Seniority is only for the respect purposes. My divergent view is that the provisions of the Cybercrime Act have not been set aside. I will expect the senior counsels to take up a petition to the High Court to declare those provisions of the Cybercrime Act illegal until they have been declared unconstitutional. They form part and parcel of the laws of this country. For now, there is no express provision. And when you look at the ruling of the learned magistrate, Honorable Nsarigo, it does not quote the section or the judgment or the authority that has declared Section 16 illegal and constitutional. The learned magistrate is entitled to that ruling. As of now, we respect the ruling that came out from the learned magistrate. Until it is reversed, that is the ruling. But the question I am raising is anybody alluding that that charge being presented, that was presented, was due to the incompetence of the Director of Public Prosecution or overstepping the mandate of the Director, his mandate, or trying to claw back the gains made in the democratic space of this country. The Director of Public Prosecution does not make law. The Director of Public Prosecution implements the law as it is. Section 16 of the Cybercrime Act went through Parliament. It was passed. It went to the President. It was assented. To date, it is a statute within the laws of this country, and the Director of Public Prosecution shall prosecute based on the laws that